if I'm correct, the Scottish Trans Alliance welcomed the lowering of the minimum age, but they also state that there should be provisions for individuals struggling with their application to request support, and these should be especially sensitive to those under 18 who may be applying without the support of a parent or a guardian. They go on to say, explainers on what GRC means and how it could be used would be helpful. Would you say that if individuals of a certain age are unable to understand what a GRC means and how it would be used, and require additional support to submit and understand an application, that perhaps lowering the minimum age would be unwise?
There are many, many reasons why an individual might need additional documentation, additional support, those with additional support needs. I certainly have, there's certainly people out there who might, for example, suffer, or not suffer, but have dyslexia or need support to translate written information into forms that you might want to submit.
The sad thing is, we know the majority of kids with dysphoria eventually grow out of it. We also know the vast majority, if left alone, will grow up to be happy young lesbians, gays or bisexuals. That's why we have a particular concern about lowering the age at which someone can get a GRC to 16. If the state steps in to validate the confused feelings of a 16-year-old girl who thinks she's a boy, this risks crystallising an identity that's just temporary. It also makes it harder for her to revert to feeling like a girl now that she's been told by the state she really is a boy.
The majority of young people with gender dysphoria will desist and become settled in their biological sex, as much as 85% in a study from 2016. I think in terms of children, I think there's good reasons to protect children from making permanent legal declarations regarding their gender, and also good reason to question opening up a pathway to puberty blockers and cross-sex hormones and other potentially irreversible treatments and surgery. And the long-term effects of a lot of that remains unclear.
But the default position is people are the sex they are. And if they want to be legally recognised as a different sex, that is a radical step, and that is an even more radical step than the social transition that worries Hilary Cass as a serious intervention for children and young people.
So we would definitely think that until the Cass review concludes that it shouldn't be reduced to 16, and then see what comes of that, because the interim report said that young people's gender identity can remain in flux until their mid-20s.
The Convention on the Rights of the Child says very clearly that when you're putting in place something for protection, for example, in relation to the justice system and the age of criminal responsibility, what you're looking to do is put in place a very high age of things like criminal responsibility, or where the minimum age is necessary to correct potential abuses in relation to things like sexual consent. Then you need to make sure that the children's rights aren't damaged through that process. But where age restrictions don't serve a protective purpose and potentially curb children's rights to development and their freedoms, then minimum ages should be avoided. And so in situations where you've got that tension between protection and autonomy, which comes up a lot in relation to things like consent and medical treatment, you should be looking to the capacity that the Registrar General might have in assessing a child's understanding or capacity. Because that would generally be only appropriate for a suitably qualified professional or medical professional in other areas of children's lives.
The UN Convention on the Rights of the Child, one of its core approaches is to recognise the evolving capacities of children and to balance that up with providing them with protection where that is needed. I noted that the Children's Commissioner did highlight that minimum age requirements require more scrutiny where they are acting to curb children's freedoms, as opposed to serving a protective function, so a protective function like in the justice system. Excluding young people from access to gender recognition procedures would be a curb to their right to private and family life, so we would not be in favour of imposing unnecessary minimum age requirements.
So in the Children's Bill, there is an assumption that a young person has the capacity to
Right.
make a decision, unless someone else, on a case-by-case basis, unless a professional says otherwise. Would you consider that that would be a useful addition to this bill to protect?
I think
young
that
people?
is assumed, I mean, due to the age of legal capacity, really establishing that young people from 16 upwards have the ability to enter into legal contracts. Now, I know that there are various ages for various things. I understand all of that. But I think the fact that we have agreed that from 16 years onwards, young people are able to make those decisions for themselves and have the legal capacity. Now, there are issues for the Registrar General around capacity more generally, not just young people,